Welcome to the Deep Dive. Today we're looking into something quite fundamental. What exactly makes an agreement legally binding here in South Africa?
Indeed. We've examined the source materials you provided, specifically those excerpts dealing with the core requirements for contracts.
And our mission really is to unpack those sources to pinpoint the critical cornerstones, wouldn't you say?
Absolutely, because understanding these is vital. The sources make that clear. You need to know this to avoid having an agreement that's just, well, void or unenforceable.
Right. And the material even gives that cautionary tale early on, the 4EV CDMO Holmes case.
Yes, that case really highlights how an agreement, even one seemingly made in good faith, can fail if it doesn't meet all the legal requirements.
It shows these aren't just abstract legal ideas, they have very real consequences. So let's dig in. The first cornerstone the sources identify is consensus.
Consensus, yes, this is the bedrock. The sources describe it as a meeting of the minds.
A meeting of the minds, meaning
Both parties must have genuinely agreed on the essential terms of the deal. There has to be a mutual understanding of what's being offered and accepted, what the obligations are.
So more than just a nod. You both need to be on the same page about the core components, like in the source's example of a sale.
Exactly. For a sales contract, you need clear agreement on the item being sold and, crucially, the price. Without that shared understanding, that consensus, the contract is fundamentally flawed from the start.
Okay, that makes sense. So once we have agreement on the what, the sources then address the who. This leads to the second cornerstone, capacity.
Correct. Capacity refers to the party's legal ability to actually enter into a binding agreement.
So who has this legal ability according to the sources?
Generally, the sources specify a few key things. You need to be of legal age, usually 18.
Yeah.
You need to be of sound mind, meaning you understand the consequences of the agreement.
Yeah.
And you shouldn't be subject to certain legal restrictions, like, for instance, being an unrehabilitated insolvent in some situations.
Right, because it wouldn't be fair or legally sound to bind someone who wasn't actually capable of making that commitment. The example given of a minor needing parental consent illustrates this protection perfectly.
It does. Lacking capacity can mean the contract isn't enforceable against that person, or it could potentially be set aside later.
Okay. Then the sources seem to group the next two elements somewhat together, legality and formalities. Let's start with legality.
Legality is perhaps the most intuitive one. The contract's purpose, its objective, must be lawful.
So you can't enforce a contract to do something illegal.
Precisely. An agreement to commit a crime, or one that's fundamentally against public policy, is simply void from the outset, according to the law discussed in our sources. Legally, it never existed.
And formalities, that sounds a bit different.
It is. Formalities concern the form the agreement takes. While many simple contracts can be verbal and still be valid, the sources highlight that South African law requires certain types of contracts to follow specific formalities.
Yeah.
Often, this means they must be in writing.
And sometimes more than just writing.
Yes, sometimes signed by the parties, maybe even witnessed, or, for certain transactions, registered with an authority.
And this loops back to that Forey case, doesn't it?
Exactly. The sources use it as a prime example. In that case, even if there was consensus and capacity for the sale of land, the agreement failed because it was verbal.
And the law specifically requires contracts for the sale of immovable property to be in writing.
Correct. So formalities aren't just red tape. They serve purposes like creating certainty, preventing disputes, and guarding against fraud. They are essential where prescribed.
All right. That covers 4. The final cornerstone mentioned in the material is possibility of performance?
Yes, possibility of performance. This means that the obligations agreed upon in the contract must actually be possible to perform at the time the contract is concluded.
It has to be doable.
Essentially, yes. If performance is objectively impossible, meaning no one could possibly perform that obligation, then the general rule cited in the sources is that the contract, or at least that impossible obligation, is unenforceable.
So if I agree to sell you the moon, that part's likely void because it's objectively impossible.
That's a good illustration. Now, the sources do mention complexities and exceptions. For example, if impossibility arises after the contract is formed, the rules can be different. Or if someone guaranteed performance even knowing it might be impossible.
They might still be liable somehow.
Potentially, yes, perhaps for damages. But the fundamental starting point is the agreed performance must be possible at the time of agreement.
Okay, so we have these five crucial elements drawn from the source material: consensus, capacity, legality, formalities, and possibility of performance. What does this all mean practically for you, the listener?
Well, it means whenever you're entering into any kind of agreement, buying a car, signing a lease, even a simple service agreement, it's incredibly useful to just pause and mentally check these points.
Ask yourself, do we both clearly understand and agree on the main terms? That's consensus.
Is everyone involved legally able to make this commitment? Capacity.
Is what we're agreeing to do actually legal?
Wow.
Legality.
Does this type of agreement require anything specific, like being in writing? Formalities.
And is it actually possible for these promises to be fulfilled? Possibility of performance.
Running through that mental checklist can help you gauge if the agreement you think you have is actually solid and enforceable under the law.
And, as the sources wisely advise, if you have any significant doubt about any of these elements, especially for important contracts.
Then seeking advice from a legal professional is always the recommended course of action. Don't leave it to chance.
Absolutely. So, to recap those five essential cornerstones identified in our source material: consensus, capacity, legality, possibility of performance, and formalities.
Get any one of those wrong, and your agreement could be invalid or unenforceable.
Which brings us to a final thought for you to consider, reflecting on what we've discussed from the sources. Knowing the importance of these five elements, how might consciously considering each one change the way you approach making agreements in the future, no matter how big or small they seem?